We are talking about Medicaid qualifications, especially in light of 2026 new rules. Things are changing, and I want to highlight those things tonight. Changes as we came into 2026, brand new numbers. But the big, beautiful bill that President Trump signed is going to make some big changes come October of this year. What do we mean when we say elder law? Everything relating to estate planning, probate, special needs benefits, military benefits, long term care benefits. That's the stuff we specialize in. I can't help you with divorce, bankruptcy, speeding tickets, immigration. I specialize only in these things. That doesn't mean that I'm the brains in the outfit. I've got a bunch of people there behind me that are very talented, very dedicated people that should be working with if you come into the firm. So now let's move on to the topic. Medicaid always updates rules around January 1st, but they don't always publish. They only published these numbers yesterday. So we're going to be talking about the updated work in this new year. Why do I write this stuff month after month? Everything that we hear is usually not true about Medicaid. We hear lots of myths, lots of bad information. Even if you heard it from another attorney, unless they're an elder law attorney, they are not most likely accurate about their information. Medicaid changes its rules at least 3 times a year. I've been doing this for 11 years. They change every year at least 3 times, if not 4, 5, 6 times. So there's a lot of misinformation and changing information. And even if you're the smartest person on the planet, you're searching on the internet, you don't know whether or not you're reading outdated information or information from a different state because every state uses different rules. So we're talking about Kentucky rules tonight. It is impossible to make too much money. There's no such thing as making too much money. You will always qualify. You might need legal help to qualify. People will say, well, we not earn too much. We have too much money in the bank. That's not true either. We can save everybody who needs the healthcare coverage 100% of their money if they are married, and at least 50% if you're a single person. So, this idea of the 5 year look back, all of that is myth. All of that is a rule, perhaps, with 100 exceptions to them. There are exceptions to every rule. So, there is no such thing as not being able to qualify. It's more possible for you to qualify than you can even imagine. It might be tedious, technical, but leave that stuff to us. We'll make it simpler for you. So, what are we going to learn tonight? I'm going to go over the qualification rules, what changed this year, talk about how income, savings, even your home is able to be saved, what benefits there are in saving it. We'll talk about some of those legal strategies that you can use to get the benefits. Here's the number one thing that I want you to hear about the big, beautiful bill. Medicaid has always allowed retroactive coverage. I had a family come to me in October starting their process and just finally got them to take the last steps because they were dragging their feet. Every single month from October until the last 2 days of January, that 4 month process, they lost $15,000 a month in benefits. So they burned $60,000 under the current rules. Once we get to October, says no more retroactivity. You must get everything done within the first 30 days or else there is no back pay available. So that's a big change, and it means thinking ahead, preparing ahead, and taking this stuff seriously is really important. And though I can still do magical things, I can't rewind the clock. And I hate to see someone burn through $15,000 a month, but that's what it comes down to. Okay, so that's the number one thing. There are new rules on all of these other things. The income limit has changed, the asset threshold has changed, and there are much stricter reviews. So let's just start with the income. The income limit has moved to $2,982 per month. If you go to the Medicaid office in Kentucky and you say, hey, I need to apply for this long-term coverage for myself, for my spouse, for my parent, when they look at your income, whether it's Social Security or retirement, railroad, teacher's retirement, they're going to look at all of them combined. And whatever that total number is, if it's over $2,982, they will tell you you do not qualify. Federal law says if you use a qualifying income trust, you can move your income into two separate buckets and then you will immediately qualify. And it doesn't matter if you make $5,000 a month, as long as your income is not above what the nursing home bill is charging you, you qualify, but you have to use this special trust, an income splitting trust called a QIT or Miller Trust, but it's really a QIT. Okay. So that's the income limit, 2982. Another thing that has changed is not in facility-based long-term care. So if you're in a nursing home, the amount of money you get to keep for your own personal needs changed last year to $60. It'll stay at $60 and it'll probably be there another 10 years. I really see Medicaid not changing that. It was over 18 years before they modified it. So that number stays the same. But if you're using home community-based waiver or the PACE program, where you're getting nursing coverage in your homes, a lot of people think you can only get this if you're going to the nursing home. You know, you can, as long as you're still mobile, you can get full at minimum of 40 hours a week or even 24-hour a day care in your home under PACE. And you can keep $2,921. So $2,921 to pay your household bills with. That's under the other two programs for personal needs allowance. The asset thresholds did not change for a single individual. If you have more than $2,000, they're going to tell you you don't qualify. So we need to seek out legal advice so you can use some of the other rules to make your assets excluded. You're going to use trusts plus some other device to take advantage of these rules. Medicaid has some ways to offset the house, ways to offset investment type income like IRAs, 401ks, CDs, money markets. There are options available for everything of that sort. The $2,000 rule still applies. But if you're a married couple, that rule has changed. It used to be that each person got $2,000. Now they've changed it to $3,000 for the married couple. So $2,000 for single, $3,000 for married couple on the asset threshold. That number doesn't really matter. If you got more than $2,000, we can still save all the money. You just got to get legal help and see what method is best for you. Any attorney should listen to what your priorities, your family dynamics, your personal needs are, and customize something for you. It's not a cookie cutter, one size fits all. There started 2 years ago to be a quality control process. And even though we would get approval for a case, just as a matter of how long does it take as we fight and fight and fight. Every time we would get 10 approvals, they would do quality control review on about 8 out of the 10. So that means they would suspend benefits and make us resubmit the application. And as that's happening, the bill is growing at the nursing home. We had one case that went through a process similar to this, and their bill got to be $642,000 before Medicaid finally paid. You can imagine the nursing home was screaming and crying, and the family was feeling like they were getting ready to go to jail. And I kept telling them, no, it'll work. It's just the system, and you got to be patient. But you can imagine that's a lot of pressure, right? I want to focus on when we're taking advantage of the provisions Medicaid provides to exempt assets and exempt certain kinds of property. You're going to need to get a penalty and be denied to make some of the other things work. So our goal is always to protect everything you've worked for. But what we need to do sometimes is get a penalty. Let me give you an example. Let's say you come to me as a single person and you've got $100,000 in the bank. And I've already said we can always save at least half. So with $100,000 in the bank, what would we need to do to save at least 50,000? We would apply for Medicaid, and at the same time we would do something with the money to create a penalty. The easiest way to do that is, let's say I have you give your $100,000 to one of your children. Medicaid is going to create a penalty. $100,000 is going to create a 10-month penalty, and they're going to say, okay, Scott, you now are ineligible for 10 months. Don't come back to us until 10 months have passed. I don't care how you have to pay for the nursing home. We're just not going to help you do it. However, the rules say that if we do it that way, that you are going to get credit while being penalized. So this is a little hard for me to illustrate without paper to write on, but if I've been penalized 10 months and I go through January, serving 1 month penalty, I go through February, I've served 2 months of penalty, I only have 8 months more to go, right? But during January and February, I had to pay for my nursing care on my own. So what the rules say is that I get credit for the money that I was able to recover to pay the nursing home bills. Let's just say it was $10,000 to pay January, 10,000 for February. I'm going to get credit for the fact that I served the 2 months. So if I reapplied for Medicaid on March 1st, I've only served 2 months of my 10-month penalty, but Medicaid is going to give me credit for having served 4 months. I know that's wacky math, but that's the way this works. So at the end of 5 months, out of my $100,000, I would have only had my child return to me $50,000, $10,000 a month to pay that bill. I'd still have $50,000, so we can save 50 using that little rule alone, that you apply for a penalty first, then you repay, you still get double credit. That little incentive Medicaid does for return, you use to your advantage. You can save half. There's other ways to save way more than that. That's just one example. Why that matters to me is because Medicaid has changed the rule. They've declared that the average cost of nursing home care is $325 a day in the state of Kentucky. The current cost of nursing care is $9,895 a month on average. $10,000 a month, you can now see how important it is to plan, right? Because if all you've got left is $100,000 and you saved that all of your life thinking you were going to be able to give to your grandkids, and now you're going to lose half of it, the money is going out the door very quickly. So if you plan 5 years in advance, you can save 100%. Married couples, we can save 100%. But if you wait so long that perhaps your spouse has already passed away and you didn't plan 5 years in advance, you're going to lose half of everything you own, with the exception of the house. We can save the house. But you can see why it's really important to plan early. Some things I want you to take away. I don't want you to make these mistakes because they really hurt you. During December, we had cases where somebody took their home and discounted it and sold it to one of their children. So a $150,000 house, they sold it for 75. That means you gave away $75,000 and you're going to be declared ineligible for at least 7 months. So giving things away for less than fair market value is going to trigger this penalty. That's a terrible thing to do. You're even going to have general practitioners tell you to do that. Don't do that. Don't give money away. There are ways to save it. Giving it away is going to come back to bite you. If you're doing it with the house, you're going to lose your capital gains exclusion, which could cost you up to $500,000 worth of lost credit. Most of the time, I see capital gains in the neighborhood of $60,000 to $100,000 worth of taxes that a person has to pay that could have been avoided if they didn't do what that bad advice said to do. But the myths that I want to talk about, that you could make too much, that you have too much income or too many assets. Not at all true. That it's too late, that if you don't do things before the 5 years, this 5 year look back that it's called, that it's too late. That is not true. It's never too late. I have people that have been in the nursing home for months, weeks, days, still can do as much for you. Come to us in advance. That's when this other rule that single person, at least 50%, married person, I can save everything. So those are myths. Placing things in other people's names, that's a myth. That's a mistake. It'll come back to bite you. Use the right tools to protect your future. Go to a skilled person. If you don't like me, you live too far from me, ask me for a referral. I'll send you to qualified people, but make sure you go to a qualified elder law attorney. Final thoughts. We no longer are going to get retroactivity. So between now and October, we got to get ourselves lined out because retroactivity will no longer exist and you got to get everything done within 30 days. Still can save 50%. Those rules still apply, but once we're in care, you can't get retroactive coverage. We have to pay something out of pocket. The other thing is that we now have a new penalty divisor, which can hurt us in a more rural area. Because if you're out in Flemingsburg and the nursing home is only $8,000 a month, we might think, oh, that's great, it's cheaper. It comes to harm you because it means we can save less money. I can still use the penalty divisor of $10,000 a month, but you're only getting credit for the actual cash. So the total monthly savings during a penalty period would be 18,000 and not a full 20,000. So you're not getting as much bang for your buck. So penalty divisor changed. The other thing is the income limit has changed. We got a pretty substantial growth in much of our retirement accounts. So that really means more people are going to have QITs. So those are the real things that I think people are going to be facing. The income limit has changed. The couple's asset limit down to 3,000 instead of 4. If both of you are needing care, that's the change. And the penalty divisor change. And then, of course, October, where we have that retroactivity lapsing. If you found tonight helpful, scan, give us a Google review, and it publicizes our advertisements to more people so that I can help them. What support is needed if a person took cash from the checking account to pay monthly expenses? Receipts would work. I'm just going to talk through it and help you see what is Medicaid looking for. If I had a receipt from the HVAC company that said it cost $6,500 and I got $6,500 cash withdrawn from the checking account and they're within a few days of one another, right, problem solved. If you don't have something like that, then go back to whoever the money was given to, have them write you out a handwritten receipt. As long as they will legibly write their name and then sign it and date it, that's an official receipt. That would work too. Now, if you took cash out and you went and paid the T-Mobile cell phone bill, you're going to want to be able to prove that the bill paid was the same person as whoever it belonged to, right? You can't pay your daughter's cell phone bill with your money. Receipt isn't going to make any difference. So the money still has to be spent on the person to whom the money belonged. But yes, a receipt is enough. If you don't have an official store receipt, you can always do a handwritten receipt. It becomes difficult if there were Amazon purchases. You got a whole lot of things in one bill. Bottom line is substantiate things in writing, explain it. And if you can explain yourself, they're going to be lenient. Where they're not going to be lenient is if you have no explanation or it just doesn't make sense, right? Let's say $100 worth of cigarettes, and you can't show in the prior 3 months worth of bank statements any purchases of cigarettes. They're not going to buy that. They're probably not going to let things like a bunch of gift cards go where it looks like you're just funneling money away. It has to be on a legitimate expense, clothing, food, utility bills, healthcare bills, things like that, and you'll be okay. Do I charge for a consultation? No, I do not. The consultations are normally not with an attorney. What the consultation normally does is allow you to come in, get to know the law firm. We get to know your case. Do we fit and match? Can we help you? Do you like what you're seeing? Then you make a choice to hire us or not. A lot of people think the consultation is come in and get legal advice from the attorney at no charge. No, we don't do that. There are some things that we have to determine before you can ever hire us. If you want us to do a power of attorney review or you're unsure, does your will need to be updated? You can send those in advance. The attorneys will look over them. If there's a problem with them, the attorney's going to meet with you and tell you why you need it to change or what you need to be thinking about before you make a change. That sort of stuff we'll do free of charge. I've always reviewed long-term care insurance policies at no charge. And the consultation, can we meet your needs to even like us? That's all at no charge. How should we go about getting a review of our existing plan? If you already have a full-blown estate plan, let's say I'm coming in from out of state, or maybe I was in Louisville and I've already got a will or a trust. That's the need where you need to have a consultation to see, is this firm right for you? You may not like our methods, our personality, our processes. So you want to test the waters. Not all law firms are the same. But let's say you've met me in a webinar, face to face, we go to church together. You think, oh, Scott's a good enough guy. I'll trust him. Then we could skip the consultation and go straight to what you're needing. Let's say I know you from being in the Rotary Club, and I've already gone to another attorney. I have an estate plan. What I would want you to do is turn those documents into my staff, let them systematize on me, and then they're either come before me or one of my other attorneys, and we're going to look over them so that we're not wasting your time by coming in face to face and then you hand over the documents, because we still have to go away and spend hours reading through everything. Now, what if you were a prior client? You did some work with me, let's say 3 or 4 years ago. I still want to go back in and review some things, and I'm probably going to have a legal assistant call you and ask some questions and say, hey, what's changed? Because it's not just about your documents. People often think lawyers just create documents. No, we create solutions. So we have to know your situation. The paper is just a byproduct. So the legal assistant's going to investigate what's changed, what are you facing now, new concerns, new births in the family, new healthcare conditions, employment, income, investments. So at that point, we can do a review, schedule the appointment, sit down together. And that typically is called either a review session or a strategy session. That's how we will know whether or not you need a lengthy review that's going to cost you, let's say, $1,500, or a quick review that might just cost you a few $100s. We'll really have to see what you're wanting us to review before I know how many hours it's going to take us. Bottom line is it depends. You can't go to the mechanic and say, before you look at my car, how much is this going to cost me? I got to look at your car to figure out how much it's going to cost. So that the same thing applies to legal work too. The first step is call and let my front facing people, that team of 5, walk you through the process and discover everything you need to know. And we'll go from there. What do you know about shielding assets through a Pension Production Act compliant annuity? You can boil it all down into an annuity. Can we create annuities that shelter? Yes, you sure can. Now, it's really going to come down to whether or not the retirement plan holder, or if it's already in some sort of an annuity investment product, what the annuity company is going to allow you to modify the contract. So it's kind of like any other investment, right? We have CDs and money markets and insurance policies. All of these investment tools are a contract. Do they have penalties for modification, or do they allow modification? Time limits where you can only do it after age 65. So what your question's really pointing to is, yes, you can use an annuity to shelter some of that retirement pension. It's going to depend upon the company. You really need to get involved with the elder law attorney as well, because what will happen when you apply for Medicaid, annuities in and of themselves don't shelter anything. Annuities fall under a Medicaid rule that gets treated like a 401k or an IRA. Principal is excluded in the annuity as long as it's found in other ways. And even if it's not, as long as it can be modified, you can still make it work so that the principal is shielded. The real struggle is when it's paying out distributions. The distributions are not shielded. It's counted as income, and it is going to go toward the nursing home if you need to access the Medicaid benefit. You got to be careful, and there are ways to do that. Most of the time, an annuity is going to have everything paying to your spouse if you have one. However, I don't like that option in deferred or retirement investment accounts, 401k, IRA, annuity. I don't like them paying to the spouse. That's too deep for this question, but it does raise your awareness to say you need somebody that really walks through this process with you. It's not like you just go buy it and it's going to be fine. It has to be customized to your situation and Kentucky's Medicaid rules. So, in short, good idea, very careful, because it may not work unless you have all of the details in the contract the way it needs to go. My annuity paid out each month and ends in 11 more months. It was funded from an IRA, and I've had taxes pulled out. So am I saying that it will be counted toward my wife? I am saying that, yes. Now, it depends upon what stage we're at. So if something happened in the next 11 months, the principal is going to be excluded. But let's say you pass, it goes to her. If you get it's still in this 11-month period, that's fine. But as you're receiving the monthly payments, that's counted. This gets complicated, but there are ways. Let's say in an IRA, even an annuity, I could have my annuity paying the payment. It's owned by me, but pay the payment to my spouse. If I'm the one needing care, then I don't lose the money that goes to the spouse. If I've passed away, she inherits it. She can't take an individual retirement account and have it distribute money to anyone else. A married person can distribute to a spouse and exclude that income from the RMD or the annuity payment, but a single person cannot. What good does it do for me to shelter the principal if every distribution flows straight through to the nursing home? That's why I don't leave that money to a spouse. I'd like to leave it to another generation younger. I would rather liquidate the thing, accelerate the taxes, because I believe that I could show you how to save taxes by getting it taxed now instead of later and not losing any RMDs. Well, why would I ever want to pay taxes sooner? I'll show you how. I've got to walk you through the process so you can see the logic behind it. The annuity is how you pay your bills. And what happens is if you did have a healthcare issue, there's no way to save this money, because they're going to say, as long as it's in an annuity, you've got to have it paid to you. They're going to make you modify the annuity further and say that if one or the other of you pass away, you have to name the state of Kentucky's Medicaid program as the beneficiary. You can't leave it to another person. So there's a lot of things to juggle in that. Is there a dollar amount for checks that are gifts to children that is okay? This comes up a lot because people assume things based on the gift tax exclusion, that you can make certain amounts and it's not countable because the gift tax exclusion says you can give $19,000 away and the government doesn't care. Medicaid rules are different, and the answer is no. There is no dollar amount that makes it okay. I have had Medicaid question $15 and hold applications up for months until we could prove where $15 went. There is no amount that they exclude. If there's a cash transfer on a bank statement, they are going to demand you prove where it went. And if it was just a gift, it's going to be a penalty. Unless you can establish that you gave 15 every time, and then it would be excluded. But if you were given $15 as a birthday gift, we gave $15 to everybody at Christmas. Medicaid doesn't care. That's a penalty. If you gave 10 people $15, you now get a $150 penalty. It's a silly, strict rule. What is the benefit of setting up a promissory note to a child? It really depends upon what the full family dynamic is. I'm going to make an assumption so I can answer the question. If the person were single who's needing nursing home care and you created a promissory note, the value would be to get rid of the principal so that you can qualify, and you would only lose the payment of the promissory note on a monthly basis to the nursing home. Let's say I've got $500,000 and this is dad's money, and dad is in really bad shape. I don't think dad'll be with me more than maybe 6 more months. So dad could loan me $500,000. If I'm paying him back $2,500 a month, the benefit is that Medicaid's helping with the bill right now. And if dad dies in 6 months, I've only lost 2,500 times 6. So it'd be $15,000. I've only lost $15,000 and I still protected the remainder of the 500,000. So $485,000 is the benefit. So the benefit is if dad dies quicker, we've saved more money. If we are talking about a married couple, the benefit of the promissory note is we're saving 100% of all the money, because that makes the money, the principal, my $500,000, 100% excluded. So there are all kinds of things you have to make that promissory note say before Medicaid will accept it, but that's the why of that. Thank you for being here. I hope I get to see some of you again. I hope I've given you some valuable information. Write us, ask us additional questions. You can call, get an appointment. You can ask through the email. We're here to serve you. I appreciate you. I hope it's been helpful. I hope you're safe out there. Have a good weekend. Bye-bye.